Hi, I'm tax attorney Jeff Collins with the firm of Jones & Collins. I want to speak with you quickly about discharging taxes in bankruptcy. I get calls every week. Someone wants to know whether it's possible to include their tax liability in a bankruptcy. Well, the quick answer is it depends. There's a few sets of rules that everyone should be aware of. Tax professionals, take note. First rule, only income taxes are dischargeable. Now, those are federal and or state income taxes, but they do not include payroll taxes, sales taxes, or excise taxes. Only income taxes are dischargeable. All right, the next rules are a series of timing rules. Now, speaking of income taxes, only tax liability that results from income tax returns that have actually been originally filed by the taxpayer are dischargeable. And the timing rules related to those are that the tax return due date must have been 3 years prior to filing the bankruptcy case. The next timing rule is that the return itself must have been filed at least 2 years prior to the bankruptcy being filed. And then the third, any tax liability, including any additional assessment of liability, say for an audit or something like that, must have been at least 240 days, which is about 8 months, prior to filing the bankruptcy. Now, speaking of those timing rules, keep in mind that certain legal actions, which may very well include the filing of a prior bankruptcy case or some other action, including some sort of collection deferment with the IRS, could very well what we call toll or temporarily stop the running of those timing rules. The last common rule for discharging taxes in bankruptcy is that if the tax is secured, then it's not dischargeable in bankruptcy. What does that mean? If a federal tax lien or even a state tax lien has been filed, then the tax is secured and not dischargeable. In some cases, secured tax liability can be made unsecured and therefore dischargeable in bankruptcy. Check with a specialist attorney that handles discharge of taxes in bankruptcy before moving forward. Okay, so those are the general rules. There are certain other specific rules that apply on a case-by-case basis. They are extremely technical, and again, they are fact-specific to your particular situation. So again, technical rules, speak with a specialist attorney that handles discharge of taxes. So many of our clients start off with the big question, what do they do about their tax liability? Discharge in bankruptcy may very well be an option. Okay, make the consultation. It may just be a fresh start for you.
We are Jones & Collins, assisting tax professionals throughout the United States. Call us today at 877-376-2292 to schedule a confidential one-on-one conference. Protect yourself.